In the book of Psalms, we read, "If the foundations be destroyed, what can the righteous do?" If the foundations be destroyed, what can the righteous do? My belief is that the foundations upon which this nation was laid, those foundations which are found in our Constitution and which providentially are consistent with the values found in the Word of God, are being eroded today, and that many of the problems that we see in our society today can be traced back to this erosion from those basic constitutional principles. What we need now is a call back to those first principles, but before we do that, I think we need to see how we have strayed away from the path. Let's look first of all once again at the framers' view of the Constitution itself. You see, their view of law was very much like their view of truth itself, because law ultimately is a reflection of truth, and you can't separate the two. You can't do justice without knowing truth. If justice is defined in Aristotle's terms as rendering to each person that which is due him, then you need to know what is due to each person. And to know that, you need to know the truth, like did he commit the murder or didn't he? So law, justice, and truth are closely related. Now, the framers viewed law like they viewed truth itself, as something that was fixed, that was absolute, and that was ordained by God. They derived this idea in large part from the Bible itself. The Bible treats truth as absolute. This idea that each person creates his own truth, or that perception is reality, certainly isn't a biblical perception. In the Old Testament, the Hebrew word that is used for truth is the word emeth, which has its roots in the idea of that which is fixed or unchanging and which meets the test of time. In the New Testament, the word for truth is aletheia, and it is identified with Jesus Christ himself, who is referred to when he says, "I am the way, the truth, and the life." And he is referred to in the book of Hebrews as the same yesterday, today, and forever. Now, it follows if Jesus is truth, and if Jesus doesn't change, then the conclusion I get from that is that truth doesn't change. The framers also derived this view in part from Sir Isaac Newton. Now, Isaac Newton, the famous scientist, lived from 1642 to 1727. He, in addition to being a great scientist, was a Bible-believing Christian who wrote extensively on the Bible, particularly on Bible prophecy. But Newton's view of the universe is that the universe consists of absolute, God-ordained, unchanging laws. Laws like the law of gravity, the law that if you sit under apple trees in the fall, you're likely to have apples fall into your head. Or the laws of mathematics, that 2 and 2 always equals 4, whether you add it here or whether you add it in China or wherever you add it. Or that chemistry, like combine 2 parts of hydrogen and 1 part of oxygen, and you're going to get water whether you do it here or on the planet Neptune or in the next galaxy. And also moral laws for the governance of man. These, likewise, in Newton's view, are ordained of God and are fixed and absolute and unchanging. Now, when the framers write in the Declaration of Independence of the laws of nature and of nature's God, they understand this much in the biblical sense and much in the Newtonian sense. And Christians and deists alike could readily embrace the Newtonian worldview as reflecting their idea of a God who has established absolute law. They also derive this view of law and this view of truth from the thinkers like Montesquieu and Blackstone and Locke and others, who taught that man's law must conform to a higher law, the law of God. And therefore, they believed that the Constitution was to be interpreted according to a fixed standard. Look at its plain meaning. And if there is any question about what the words mean, look to the intent of those who wrote it. Jurisprudence of original intent. Madison, who many call the father of the Constitution, said, "If the sense in which the Constitution was accepted and ratified by the nation be not the guide in expounding it, there can be no security for a faithful exercise of its powers. Jefferson was not at the convention, but he was president during a formative period of constitutional history. Jefferson said, "The Constitution on which our Union rests shall be administered by me according to the safe and honest meaning contemplated by the plain understanding of the people of the United States at the time of its adoption." And Washington said, he chaired the convention, "If in the opinion of the people the distribution or modification of the constitutional powers be at any particular wrong, let it be corrected by an amendment in the way the Constitution designates. But let there be no change by usurpation. Though this may in one instance be the instrument of good, it is the customary weapon by which free governments are destroyed." In other words, if we don't like what the Constitution says, amend it, but don't just misinterpret it and stretch it beyond recognition. Since that time, however, there has been a changing view of law that has resulted from a changing view of truth. George Wilhelm Friedrich Hegel, a German thinker from 1770 to 1831, Hegel's main contribution to Western thought was his denial that truth is absolute and unchanging, and rather, he says, truth evolves and changes by a dialectical process of a thesis and an antithesis and a synthesis and so on. But truth is a changing process. As Hegel used to say, it is not being, but becoming that really constitutes truth. Auguste Comte. Comte lived from 1789 to 1857. He's referred to as the father of positivism. That's a term we don't often use. So essentially, positivism means that the only meaningful truth is that which can be empirically verified. That is, that which you can verify with your senses. I could verify this pulpit by banging on it like that. And as I do that, I know that this pulpit exists. I have felt it, I have heard it, I see it. I don't think I need to taste it or smell it, but I have verified the existence of this pulpit with my senses. Comte would say that's the only real way we know anything. If you can't see it or hear it or touch it or taste it or smell it or put it under a microscope and analyze it, it really isn't meaningful knowledge. Well, what does that do then to concepts like God, or like God-given rights, or equality, or human dignity, or natural law? Comte would say, I didn't say those things don't exist. I also didn't say they do. I'm saying those concepts are meaningless because they cannot be empirically verified. And then we go to Charles Darwin. Darwin is known today as the father of evolution, although evolutionary thought goes back thousands of years, back to the ancient Romans and ancient Greeks, and perhaps even before that. Darwin simply popularized a scientific model of origins through his publication of his book, The Origin of Species, in 1859. Many have said that the reason The Origin of Species was so readily accepted, despite the lack of evidence presented in it, was that it confirmed many intellectuals in the Western world at this time into believing what they already wanted to believe, that they could survive in a world without God. Essentially, Darwin's model of origins, to oversimplify it a great deal, said that, first of all, we have overproduction of species. That is, any species left to itself without natural enemies is going to reproduce and multiply beyond its number. It's going to increase. Now, since we've got a limited environment, we have a struggle for survival. Let's say that this county can only support 1 million rabbits. If we get over 1 million rabbits, there is going to be a struggle for survival. Some rabbits are going to survive, some aren't. Now, which rabbits are going to survive? Darwin's answer is survival of the fittest. And then the fourth principle, reproduction of like kinds. The idea that not only that rabbits produce baby rabbits and pigs produce baby pigs, but that in general, smart rabbits are going to produce smart baby rabbits, and long-legged rabbits are going to produce long-legged baby rabbits, and so on. And so the result is we've got a new and more fit generation But we still have this overproduction going on, so now we've got a continuing struggle for survival of the fittest, only now it's the fittest of the fit. And gradually, over long periods of time, the species gets more and more fit and evolves and perhaps even transitions into other species, even though the evidence of that, the best thing to say about the missing link is that it's still missing. Now, Darwin himself did not develop this into a philosophical worldview. He presented it simply as a model of origins. But another man, Herbert Spencer, and others along with him, but primarily Herbert Spencer, who lived from 1820 to 1903, made Darwin's model a philosophy and a worldview. It's been said that Herbert Spencer was possibly the most influential intellectual in America in the 3 decades following the Civil War, and that it was impossible to be active in any field of intellectual endeavor during that period without mastering Spencer. Essentially, what Spencer tried to do was to take Darwin's model of origins, evolution, and make it the unifying principle that applies in every area of academic thought. He wrote extensively on political science, on sociology, on law, on psychology, social statics, many, many other subjects. But he's probably best known for his works on economics. And his works on economics are often called social Darwinism. Now, social Darwinism is a laissez-faire form of capitalism, different from biblical capitalism. The idea here was that there is to be tooth and claw, cutthroat competition, because it is your duty as a businessman to drive your competitor out of business and force him to starve, because in so doing, you are simply pursuing Darwin's laws of evolution. You're following survival of the fittest. And the result is that everybody benefits, because the most fit businesses survive and produce better goods at lower prices, and so the consumers ultimately benefit. But that's Spencer's version of social Darwinist economics, in contrast to biblical capitalism, which also stresses individual initiative and work, but also stresses moral responsibility and compassion. Freudian and Jungian psychology both can be traced in their roots to evolutionary thought, as can much of modern sociology, anthropology, and many other subjects. Even liberal biblical criticism, that which views the Bible as an evolving, changing document, for example, viewing the first 5 books of the Bible as having been written over a long period of time by 4 authors, the JEDP thesis, rather than by Moses, as they claim to be, and as our Lord Jesus Christ attributed them. Even this has its roots in the idea of Darwinist thought. Herbert Hahn, in a recent book, and Hahn, by the way, shares this liberal criticism, but he openly acknowledges that many of the liberal critics of the Bible did not base their views simply on an objective reading of the evidence, but rather that it fitted in with their evolutionary worldview. In their view, these things could not have been written back in the days of Moses, and Abraham could not have believed in one monotheistic God, Jehovah, because he was still too much of an ape. He hadn't evolved to that point yet. And so viewing the development of the Bible as an evolving process rather than as God's revelation also has its roots in evolutionary thought. Now, it would follow then that if evolution affects all these other areas of thought, naturally, evolution is going to affect the way we look at law as well. And as a result, we see a theory of law developing at Harvard Law School in the 1870s that we know today as legal positivism. The leader of the school back in those days was Christopher Columbus Langdell, the dean of the Harvard Law School, and his successor, Roscoe Pound, the subsequent dean, and one of their students, who later became a professor and a Supreme Court Justice, Oliver Wendell Holmes, Jr., were some of the leading proponents of this view. And you could probably summarize their view in 5 basic premises. First, there are no divine absolutes in law, or if there are, they are irrelevant to the modern legal system. God did not author any principles, any standards, and if he did, we don't consider them in developing our law today. Well, if you accept the first point, the second kind of follows from it. Law is simply man-made. After all, if we've written God out of the picture, then who's left to establish law but man? And so law is law, not because God has ordained it so and because the state is trying to understand God's law and apply it. Rather, law is law because the highest human institution, the state, has made it law and has the muscle to back it up. That's all law is in this view. Third principle, then, is that law evolves as man evolves. After all, if man is an evolving creature, and if there are no divine absolutes to hold law stable, then naturally, as man evolves, so the law that man pronounces is going to evolve as well. Well, how does law evolve? The statute books don't just multiply, and they do multiply, but men make them multiply, but they don't just simply rewrite themselves. Law evolves because judges guide the evolution of law. Somebody has to do it, and in the positivist view, those who are responsible for doing so are the judges. Now, how do they guide the evolution of law? The answer is by writing decisions. When a judge writes a decision, he is aiding in this process of evolving law. And so, if we want to study law the scientific way, how do we do it? The answer is we read the original sources, the decisions that the judges have written, because that, in the positivist view, is the actual source of law. Now, if you'd gone to law school 150 years ago, you would have had a very different system. You probably wouldn't have gone to law school at that time, actually. If you had wanted to become a lawyer, you would have read on your own the works of Blackstone and Cook and Bracton and many other works like this, those of Chancellor Kent and the like. And then you would have apprenticed yourself to a successful lawyer and did a lot of his pleadings for him and his filing and observed him in court and the like. And then you'd be ready to sit for the bar exam. And some of the greatest lawyers in American history, like Abraham Lincoln and Clarence Darrow and the great Chief Justice, John Marshall, never went to law school. Today, when you go to law school, the majority of what you do is study case law. Read the decisions of judges, because that, in the positivist view, is the actual source of law. Now, the result of this is a view that has come to be known today as the living constitution view. How many of you have heard that term, living constitution? A lot of you have. It's an attractive term because nobody except John Eidsmoe would want a dead constitution. But it's also a dangerous view. What it means is that judges are not bound by the intent of the framers, but rather are free to give new meanings to the Constitution as time goes on. In fact, some legal scholars have even referred to the Supreme Court as a continuing constitutional convention, and have suggested that the decisions of the Supreme Court are to be considered as just as authoritative as the Constitution itself. Now, judges who hold this view will feel free to create, or as they might say, recognize rights that are not found anywhere in the Constitution, like the right to abortion, or the right to engage in homosexual conduct. Now, let's get an example here as to how this evolving standard or this living constitution works in practice. There was a case back in 1972, Furman versus Georgia, in which the Supreme Court considered the issue of capital punishment, and by a 5-4 vote concluded that capital punishment, as practiced in that case, was unconstitutional. They didn't agree as to why. In fact, there were 9 separate opinions written in the case. A couple of the justices said it violated equal protection because it discriminates against the minorities and the poor. A couple of them said that it violates due process in various ways. 2 of them, though, Brennan and Marshall, said that capital punishment is always unconstitutional today because it is cruel and unusual punishment in violation of the 8th Amendment. Now, it is true the 8th Amendment prohibits cruel and unusual punishment. But when the framers used that term, it's doubtful that they intended to abolish capital punishment, because it was almost universally accepted then, and because at the same time In the Fifth Amendment, they expressly referred to capital punishment. It doesn't seem likely that they would sanction it on the Fifth and abolish it in the Eighth. But that doesn't bother Brennan and Marshall at all. Brennan and Marshall simply say that the meaning of the amendment is not fixed and static. Rather, it must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. In other words, they're saying even if capital punishment was acceptable by the primitive and barbaric standards of 1789, it is cruel and unusual by the humane and enlightened standards of today. That is the evolving Constitution or living Constitution in practice. I see some dangers into this approach. And one of the dangers that I see is that under this approach, human rights are not secure. The same court that can read into the Constitution rights that aren't there, like abortion and homosexual conduct, can read out of the Constitution or water down rights that are there, like property rights or contract rights or the right to own firearms and the right to free exercise of religion. Brennan, when he spoke to a symposium at Georgetown University some years ago on this idea of the living, evolving Constitution, in which he said that the evolutionary principle is the true interpretive genius of the Constitution, Justice Brennan at that time said that the upward march of our constitutional history should always be toward a greater recognition of human dignity. Well, I don't share that kind of optimism. I don't see any guarantees in history that we are always or even generally moving toward a greater recognition of human rights, of human equality, of human dignity. In fact, history could just as easily move the opposite direction. And if that is the case, if we do move to a new age of barbarism, then the protections of the Constitution under this living Constitution approach could become meaningless. And Brennan's words could be quoted right back. Let's say if somebody is sentenced to be drawn and quartered or skinned alive, and you object that the framers would call that cruel and unusual, the court would say, oh yes, but as Justice Brennan said, the meaning of the amendment is not fixed and static. Rather, it must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Given the propensity for violence that we see all around us today and in our media and the like, we do not think the skinning alive is cruel and unusual by today's broad-minded and tolerant standard, and so we direct that the defendant be delivered to the taxidermist so the execution can begin. There is no firm guarantee for human rights with an evolving standard, nor is there any guarantee that judges are going to be more enlightened or forward-looking or protective of human rights than the population as a whole. In fact, I would say that while that may have been true in some past decades, for much of history, the very opposite has been true. Another danger of the living Constitution approach is that it leads to big government. Through the strained interpretations that the court has given to the General Welfare Clause, the Interstate Commerce Clause, the Necessary and Proper Clause, the Contract Clause, the Due Process Clause, and others, the courts have opened the door to vast expansions of the size and scope of government at all levels. For example, in 1789, when George Washington took office, he had a total of 350 federal civilian employees. In 1832, the total federal budget was $11 million. Today, it is $1.4 trillion. Now, if you were to multiply that $11 million budget by, let's say, 1,000 times, you'd get 11 billion. If you multiply it by 10,000 times, you'd get 110 billion. If you multiply it by 100,000 times, you would get 1.1 trillion, but in fact, the federal budget is about 1.4 trillion in 94 and to be 1.5 trillion in 95. And even considering population growth and inflation, it is obvious that the scope of government has grown tremendously. We've already talked about income tax, and the very growth of income tax is another demonstration of the growth of government. And since 1900, the total number of government laws and regulations the average citizen is required to obey has increased by 3,000%. This increase of government control and government services leads to a corresponding decrease in individual liberty and individual responsibility. A third danger of this approach is that if the state is the highest authority and there is no higher law, then how can there be such a thing as an unjust law? It must be just because the highest arbiter of truth itself, the state, has said so. And finally, it leads to judicial tyranny. In The Federalist, Hamilton argues that the judiciary is the least dangerous branch of government because its powers are limited to interpreting the Constitution and the laws of the United States. He didn't anticipate, though, that the courts would start using this evolving standard. He assumed that the Constitution would be interpreted according to a fixed standard. But we've moved away from that approach. And in the new approach, we follow judicial precedents one right after another and get further and further decisions that go further from the Constitution itself. Several justices have commented on this. Justice Felix Frankfurter used to say, "What governs is the Constitution, and not what we have written about it." Chief Justice Rehnquist said, "No amount of repetition of historical errors in judicial opinions can make the errors true." Chancellor James Kent of the New York courts in the early 1800s said, "If we do away with original intent, then judges will be free to roam at large in the trackless fields of their own imaginations." There's a professor at the University of Texas School of Law, Professor Lino Graglia, who puts it very bluntly. He says, "Judicial usurpation of legislative power has become so common and so complete that the Supreme Court has become our most powerful and important instrument of government in terms of determining the nature and quality of American life. Questions literally of life and death, like abortion and capital punishment, of public morality, control of pornography, prayer in the schools, and government aid to religious schools, of public safety, criminal procedure, and street demonstrations, are all now in the hands of judges under the guise of questions of constitutional law. The fact that the Constitution says nothing of, say, abortion, and indeed explicitly and repeatedly recognizes the capital punishment the court has come close to prohibiting, has made no difference. The result is that the central truth of constitutional law today is that it has nothing to do with the Constitution, except that the words due process or equal protection are almost always used by the judges in stating their conclusions. Not to put too fine a point on it, constitutional law has become a fraud, a cover for a system of government by the majority vote of a 9-person committee of lawyers, unelected, and holding office for life. Chief Justice Charles Evans Hughes used to say, "We are under a Constitution, but the Constitution is what the judges say it is." Now, where did they get a view of truth like that? I would say it came straight out of not just Christopher Columbus Langdell or Roscoe Pound or Darwin or Hegel or Kant. I'd say it comes back to Lewis Carroll. Remember when Humpty Dumpty says in Through the Looking Glass, "When I use a word, it means exactly what I want it to mean, nothing more and nothing less." And Alice asks, the question is, can you make words mean whatever you want them to mean? And Humpty Dumpty answers, the question is, who is to be master? That is all. And he's right. If judges are free to make the words of the Constitution mean whatever they want them to mean, then judges have become our masters. What is the solution? Back to the Constitution as interpreted by the framers, and back to the biblical principles the framers held. I think William Penn put it very well, the Quaker who'd served time in prison in England for his beliefs and became the founder of Pennsylvania. Men must choose to be governed by God or condemn themselves to be governed by tyrants.